Imagine this. You are a veteran. You served your country. You came home with injuries that follow you every day, not just physical ones but the kind that live inside your mind. Your doctor recommends medical marijuana as part of your treatment. It is legal in your state. You have a medical card. You are following every rule your state has set. Then one day, you walk into a licensed gun store to legally purchase a firearm. You pick up the federal form. You start reading the questions. And right there, in bold print, you see a warning that stops you cold. It tells you that no matter what your state says, no matter what your doctor prescribed, if you use marijuana, you are federally considered an unlawful user. And that means you cannot legally buy that gun. You are not a criminal. You are not dangerous. You are a patient following a doctor's orders. But under federal law for years, that distinction did not matter. But here is what most people still do not realize. That may finally be changing. And the change is bigger than most headlines are letting on. The Bureau of Alcohol, Tobacco, Firearms and Explosives, the ATF, has proposed revisions to one of the most important federal documents in the American gun system. It is called the Firearms Transaction Record. Officially it is known as ATF Form 4473. And if you have ever purchased a firearm from a federally licensed dealer anywhere in the United States, you have filled it out. This form has one specific question that has quietly affected millions of Americans for decades. It asks whether the buyer is an unlawful user of or addicted to marijuana or any other controlled substance. For years, that question came with a bold federal warning. The warning clearly stated that marijuana is federally illegal regardless of what your state has done, medical card or not, doctor's recommendation or not, state dispensary receipt or not. The federal position was absolute. Now the ATF is proposing to change that language, and while it may look like a simple paperwork update on the surface, the legal and human impact of this revision is enormous. Let us break down exactly what is happening, why it matters, and what you need to know right now. The proposed new language on Form 4473 shifts the focus of the marijuana prohibition specifically to recreational use. The updated wording states that federal law does not permit the use or possession of marijuana for recreational purposes. What is critically different is what the new language no longer says. It removes the explicit statement that medical marijuana is treated the same as recreational marijuana under federal law. That single omission is not an accident. It is a signal, a formal federal acknowledgement that medical marijuana and recreational marijuana are no longer viewed in the same legal category. This matters enormously. For years, an estimated 4 million Americans have unknowingly been caught in what legal experts have called a quiet trap. These are ordinary law-abiding citizens, people who use medical marijuana legally under state law, people who also want to exercise their Second Amendment rights. Under the old federal framework, they were forced to choose between their medical treatment and their constitutional rights. That is not a small thing. That is a profound conflict between state law and federal law, playing out in the lives of millions of real people. Think about who is affected here. Veterans managing post-traumatic stress, chronic pain, or depression through state-authorized medical cannabis programs. Parents dealing with serious medical conditions. Seniors managing pain with doctor-prescribed cannabis in states where it is fully legal. In Florida alone, approximately 1 million residents are registered medical marijuana patients. And this is not just a Florida issue. Across the country, millions of Americans are registered in state medical programs while also being legal gun owners or wanting to become one. This is where many people make a serious mistake. Some people assume that because their state has legalized medical marijuana, they are fully protected when purchasing a firearm. That assumption has been dangerously wrong under the old federal framework. And even now, with these proposed changes, the situation remains complex. You must understand exactly where things stand. Here is the key legal reality you need to hold on to. The federal law that created this conflict in the first place has not been repealed. It is Section 922, subsection G, number 3 of Title 18 of the United States Code. This law prohibits any person who is an unlawful user of a controlled substance from possessing firearms. That law is still on the books. Only Congress can repeal it. Only the federal courts can declare it unconstitutional. What the ATF is changing is how their form presents the question to buyers at the point of purchase. The underlying statute remains. What this means practically is that the proposed form change does not automatically grant medical marijuana patients the legal right to purchase firearms without risk. What it does is create meaningful legal space. It signals that the federal government is beginning to recognize a distinction. It opens the door to legal challenges, and it reflects a broader shift happening at multiple levels of the federal government simultaneously. Here is something that surprises a lot of people. This form revision is not happening in isolation. It is part of a convergence of significant federal developments, all pointing in the same direction at the same time. First, the Trump administration moved to reschedule marijuana from a Schedule 1 to a Schedule 3 controlled substance under federal law. This is a massive shift in how the federal government classifies cannabis. Schedule 1 means no accepted medical use and high potential for abuse. Schedule 3 means accepted medical use is recognized. This reclassification is the legal foundation that makes the ATF Form revision possible. Second, the United States Supreme Court is currently reviewing a major case that directly challenges the federal law prohibiting gun ownership for drug users. The case is known as United States v. Hemani. The court is examining whether the federal ban on firearm possession for unlawful drug users violates the Second Amendment. A ruling in favor of the challengers could strike down or severely limit Section 922G3 entirely. Third, the acting Attorney General has indicated that the Department of Justice may soon stop aggressively defending the law that disarms marijuana consumers. The Second Amendment Foundation, one of the most prominent gun rights organizations in the country, has publicly stated it is happy to see the new draft form already reflects the rescheduling of cannabis and that medical marijuana use is no longer listed as a disqualifying factor. When you see the ATF, the DOJ, the Supreme Court, and the federal reclassification process all moving in a similar direction at the same time, that is not coincidence. That is a policy landscape shifting in real time. Now let us talk about what this means for you specifically and what the real risks still are today. If you are a medical marijuana patient and you want to purchase a firearm, you must understand this clearly. The proposed form change is still in the public comment phase. As of right now, the old federal prohibition has not been officially removed. The ATF is accepting public comments on the revised Form 4473 through July 7 of 2026. Until the new form is finalized and officially adopted and until the underlying federal statute is changed or struck down, the legal risk for medical marijuana patients purchasing firearms remains real. Lying on Form 4473 is a federal felony under 18 United States Code Section 1001. People have faced federal prosecution for this. The consequences are serious. Up to 10 years in federal prison is possible under the related firearms possession statute if a person is found to have violated Section 922G3. This is not just a technicality, this is federal criminal law. Most people do not realize this until it becomes a real problem in their lives. So what should you actually do right now? Several things. If you are a medical marijuana patient who is also a gun owner or thinking about becoming one, consult with a licensed firearms attorney in your state before making any decisions. The intersection of state cannabis law, federal firearms law, and now this evolving regulatory landscape is genuinely complex. The rules are changing, but they have not fully changed yet. Getting professional legal guidance is not just a recommendation in some situations. It is the smart and necessary thing to do. Follow this case closely. The Supreme Court decision in United States versus Hemani could come at any time and could dramatically reshape the legal landscape overnight. Watch for announcements from the ATF about the final version of Form 4473 following the close of the public comment period. If you are a veteran who has avoided enrolling in a medical marijuana program specifically because you feared losing your gun rights, this is the moment to start paying close attention. The legal environment that made that fear rational is beginning to change. It is not fully changed yet, but the momentum is real. Let us do a quick recap of everything you now know. The ATF has proposed revisions to Form 4473, the federal gun purchase form, that remove the explicit language treating medical marijuana the same as illegal drug use. This change was made possible by the federal reclassification of marijuana from Schedule 1 to Schedule 3. An estimated 4 million Americans have been quietly caught between state medical marijuana law and federal firearms law for decades. The underlying federal prohibition under Section 922G3 has not been repealed and remains in effect during this transition. The Supreme Court is reviewing a direct constitutional challenge to that law right now. Lying on the firearms purchase form remains a federal felony, regardless of how the form is revised. And the legal landscape is shifting faster than most people realize. This is a rare moment when multiple systems of government, regulatory, executive, and judicial, are all moving at once toward a significant change in American law. The outcome is not yet finalized, but the direction is becoming clear. Stay informed. Check the official ATF website at atf.gov for updates on the Form 4473 public comment process. Follow the Supreme Court case United States versus Hemani for a ruling that could change everything. If you or someone you know is directly affected by this issue, please share this video. The more people understand what is actually happening in real time, the better prepared they will be to protect their rights and make decisions safely. If this kind of in-depth, accurate coverage of the laws and policy changes that affect your real life is important to you, subscribe to this channel. We do not chase headlines. We break down what matters, what it actually means, and what you need to do about it. New videos go up regularly, and the next one may cover something that affects you even more directly. The rules are changing. Make sure you know what they are before they change your life.